Hello, and welcome to the next series of webinars the Worker Health and Safety Centre is hosting on health and safety issues related to COVID-19. I'm Nancy Hutchison, training representative with the Workers Health and Safety Centre, Ontario's only designated health and safety training centre. We've been working hard to answer your questions on COVID-19 individually and through our hosted website. Let's begin. The objective of this session is to bring awareness that the amendments were made to the Criminal Code of Canada. We find that many employers and workers don't realize that the Criminal Code was changed to include criminal negligence charges for health and safety non-compliance. We'll look at the history of why it's there and what triggered it, which means we'll be looking at the Westray Mine disaster. We'll look at some past convictions and why calls are growing louder for charges as a result of COVID-19 in Alberta. And when we look at Alberta, you can see from this incredible newspaper headline from just April 24th, a stunning comparison, the Cargill meat plant and the Westray Mine. The union at Cargill, they foresaw this disaster in Alberta too. When asked for a 2-week plant shutdown, there were already 38 COVID cases in the plant. The plant was declared safe by a virtual inspection by a health and safety inspector at that time. With no plant shutdown, there's over 800 plus cases and 1 death. And later, we're going to talk about why the Alberta Federation of Labour is calling now for a criminal investigation. So where did this law come from, the Westray Law? What was the event that created the change? Well, at 5:18 a.m. on May 9, 1982, at the Westray coal mine, there was a catastrophic underground explosion. The workers foresaw this disaster as well. There was a coal mine, methane gas, a spark, and negligence. Westray was a non-union mine. The United Steelworkers Union was called to organize them, to give them a voice to the health and safety issues they were experiencing. The union drive was almost complete when the mine blew up. The workers were scared. They knew there was little work in the area. And the bosses kept telling them there was a stack of applications on his desk. If you didn't like it, you can go and work somewhere else. They saw workers getting fired for speaking out. And there was a government inspectors that were not acting and not protecting workers. It was the tragedy that changed everything. Have a look at this photo. This is where the fireball blew out during the explosion. This is the entrance ramp to the underground mine from the surface. No worker would have had a chance of survival. Even if there had been 1,000 workers on that shift, they all would have died. And when you pull the onion peel off, it became clear this accident wasn't really an accident. It was layers of neglect and negligence with systematic failures. The Westray Mine also, if you can believe it, won the prestigious J.T. Ryan Award for the safest coal mine in Canada, less than 2 weeks before the mine blew up. It was all a sham. The records that they submitted for the award were false and frauds. And you may not know that there's still 11 bodies underground at Westray that were unretrievable, too dangerous to get them. So that workplace became their burial place. Westray mine owners and management knew that the Frood coal seam had a history of unstable ground. The infamous Spring Hill mine disasters, the Allen mine disasters, the Drummond disasters, Albion mine explosion, and more were on that same mine seam, killing hundreds of miners over the decades. And with Westray, there was nothing different. There was a lack of worker training. They went from the street to the underground with little or no training. And the mine was constantly changing their flawed mine designs, Methane gas detectors were being disabled and ignored, and in fact shut off for being too annoying. During the first 2 months of operation, there had been 4 underground roof falls. That meant when a worker went back to the place where they worked their last shift, it was no longer there. It was buried, and so was their equipment. A complete warning sign. There was a lack of stone dusting to neutralize the coal's explosive nature. The alarm lights were flashing, screaming. The workers were raising health and safety issues, but the employer carried on with no enforcement from the inspectors. There was an outcry for justice, and the United Steelworkers led the demand for a public inquiry with the families. There had to be answers, and the steelworkers made a commitment. We will represent those dead miners and the surviving miners. The Westray miners even got their own local union charter following the explosion. And the union did not receive 1 cent in dues and spent millions to represent their Westray members over the years. So finally, time for the inquiry. Justice Peter Richards, a former Nova Scotia Supreme Court judge, was named the commissioner of the inquiry. The inquiry was called within days of the explosion, but it took years to begin because of some of the provincial legal and court actions, such as they were, amounted to nothing, but the process couldn't be interfered with or tainted, so the inquiry had to wait. That's why it took 5 years. But the report ended up being a scathing 800-page report, a 3-volume set of despair. The title is telling enough, The Westray Story, A Predictable Path to Disaster. Over 70 witnesses were heard from, and the most powerful and gut-wrenching testimony, of course, came from the surviving workers themselves. There were a total of 74 recommendations in the inquiry report, and thankfully number 73 was among them, and it was golden for workers. It read, the Government of Canada, through the Department of Justice, should introduce in the Parliament of Canada such amendments to legislation as are necessary to ensure that corporate executives and their directors are held properly accountable for workplace safety. That was the recommendation that was critical to start the process to change the legislation. Changing the Criminal Code of Canada is no simple task. It took 10 years of lobbying. All members of Parliament in Ottawa, at the House of Commons, all political parties had to agree to get the buy-in and support. I had the privilege of being one of the lobbyists with the steelworkers on the Hill, joining that lobby effort. It was hard work, and we'd get close many times. And then the House session would be prorogued, or an election would be called, and we'd all have to start at square one again. But the steelworkers, the labor movement, and the families never gave up. We knew it was the only chance to get the changes that are noted on this slide. So finally, after 10 long years, remember the mine exploded in 1992, and the Westray Bill became law in 2004. Everyone who undertakes or has the authority to direct how another person does work or performs a task is under a legal duty to take reasonable steps to prevent bodily harm to that person and any other person arising from that task. And it included everyone is criminally negligent who is doing anything or in omitting to do anything that is his duty to do, shows wanton or reckless disregard for the lives or safety of other persons. Powerful, powerful. Wanton disregard is a legal term that describes an individual's extreme lack of care for the well-being of another. Reckless is a behavior that has led to damage, injury, or death. This is more than a violation of a legal duty. It's describing being grossly negligent or grossly careless. Under the Criminal Code of Canada, this is the ultimate conviction and punishment. Jail terms, a criminal record. So all health and safety matters at the workplace must be taken extremely seriously from all levels of the organization. One of the first convictions was in Quebec, Transpave Inc., 2008. 23-year-old worker was crushed to death. The company was charged criminally, but after much plea bargaining, it resulted in a very small $110,000 fine. There were a few more convictions where workers had died with little enforcement or penalties. Tokens, really. This wasn't the reason or the intent of the criminal code changes. It wasn't supposed to be fluff. Where was the fear of the courts when you don't protect the workers? Where were the large fines? Where were the jail terms? Was this just turning into a paper tiger? But then Metron happened. Christmas Eve 2009 on Kipling Avenue in Toronto, around 4 p.m. 7 workers on a swing stage working for Metron Construction, repairing balconies. The deadline they had to meet was December 31st, so the company could get their bonuses. The swing stage split in half. 5 workers fell, 13 stories. 4 died, 1 critically injured. 1 had on a harness and another hung on and pulled himself up. It was a quadruple fatality and a life-changing injury. There was no PPE, safety harnesses, available. The swing stage was approximately 1,000 pounds overweight with the cement, the tools, the men. The swing stage was a defective design, had defective welding. There were no manuals, no markings, no serial number, no labels, no maximum weights, no PN, professional engineer sign-off. That was the swing stage those workers stepped on. And think of the chaos at the scene on Christmas Eve. And the 911 calls. Apparently the operators finally just had to say, we know. Ministry of Labour inspector laid charges under the Provincial Offences Act in Ontario. It's the police who lay charges under the Criminal Code. Years of court cases and appeals for Metron. The original fine was a shockingly low $200,000 for 4 deaths. The Crown took the unusual step to appeal that. The Court of Appeal increased the fine to $750,000, more appropriate fine for extreme criminal negligence, and the project manager was given a 3.5-year jail term for his negligence. The first jail term served. So this brings us back to Alberta. Another Westray or Metron. The United Food and Commercial Workers Union president said the work was unsafe. They couldn't distance the 2 meters. They were endangering workers. Literally, workers were elbow to elbow in a moist, cool environment. An Alberta Health and Safety Inspector did their virtual inspection for the complaint off-site and declared the protections were in place. They said they're safe, it's good to go. And the Minister of Agriculture agreed. Not very good odds for support for those workers. When the union president asked for a temporary 2-week shutdown, there were 38 cases at the plant. Now, over 558 and 1 worker dead. You know, we're hearing even this morning, well over 800 COVID cases linked to the Cargill plant. Numbers are changing by the hour. The phrase going viral is exactly what COVID-19 did, and exactly why the union was trying to sound this alarm. Coincidence or negligence? 3 very different workplaces, happened years, decades apart. The components, though, for the perfect storm made these tragedies happen. It wasn't their industry or sector, it was the lack of care, and health and safety protections for the workers. Westrays can happen anywhere, in a school, in a hospital, in a factory, in a restaurant, or in a nursing home. But why are so few charges and prosecutions being held? Police are first on the scene in any fatality. We hope they are never too quick to hand over the scene to the Ministry of Labour inspectors. Remember, an accident isn't always an accident. There is a continuous move to change the mindset of police, that workplace fatalities can be criminal. With Metron, if it wasn't for Detective Kevin Sador out of Toronto, things could have been very different. He had 4 dead bodies on the ground and one 21-year-old trying to get up after falling 13 stories. He had more than a gut feeling that he wanted to do a thorough investigation. He knew it didn't appear as obvious as it looked. There was even a debate with the Ministry of Labour inspector at the time, and he said he would release the scene when he was ready. He had a gut feeling that this would be both an industrial and criminal investigation, and that they would need each other's expertise. If it wasn't for Detective Sador's determination, persistence, and moral obligation to the victims that kept him so focused, this case could have turned out very differently. In certain cases, there could be a question of officially induced error. This is a legal defense argument. The argument is that a person can't be negligent if he or she just followed the direction of the government experts, can they? In this case, the company might argue that they followed the lead of the government or the labour inspectors, therefore clear of any negligence. In Cargill, the Alberta Ministry of Labour may have been wrong to rule that the plant was safe, and the evidence on that is now clear. 800 plus COVID cases linked. Could the company still be successful in evading consequences by arguing it was right because it followed the inspector's decision? So do bad MOL decisions shield criminal actors from negligence? And how do these decisions get made anyway? Do they let the inspectors act independently to do their job? Or is their direction coming from elsewhere? We don't know, but these are puzzling and maybe disturbing issues that we have to keep thinking about. So ultimately, the employer's duties and legal duties must be taken very serious at all times, but especially now during COVID-19, because we know there's a killer out there. So are you taking every precaution reasonable for the protection of the workers? Is the PPE being provided? And is the personal protective equipment, PPE, adequate for the job? Are all necessary precautions being taken? We must always remember that there is no penalty greater than the death of a loved one. Thank you for joining us today, and I hope you found this information useful and helpful. Please fill out this short survey and submit it. It would be most appreciated. And I will take questions now, but for more information, please be sure to visit our COVID-19 resource page, and you will find a number of related documents and material on COVID-19. And I'll take your questions now. Let me have a look. Okay, I have a question. Can a company be charged under the criminal code as well as an individual of a company be charged? Yes, that's a good question. And the answer would be yes. A company can be charged independently, as was in Transfave. And we also saw that there can be charges for individuals in the cases of Metron. So it can be either or both. Let me look here, a couple other questions coming through. Are there time limits when a company or a person can be charged under the criminal code? Well, the Criminal Code of Canada is different than the Provincial Offences Act in a specific province. The Ministry of Labour has 1 year to lay charges, but under the Criminal Code of Canada, there is no statute of limitations. So criminal charges can come later, much later. And we see this when we're watching shows like Cold Case, when we see those cases and charges can be laid much, much later. Let me look. When hearing of the Ontario Nurses Association that they had to go to court to get adequate personal protective equipment for long-term care homes and their workers to be protected, would that be a case for the criminal code? Well, thank you for that question. And we are seeing things unfold like this, and it's not just the ONA, it's also, we're seeing so many cases through the SEIU union, and they lost another member yesterday, when they're having to go to outside organizations, be it the court or the Ontario Labour Relations Board, to get a ruling if they can obtain the personal protective equipment that they need. We're not sure with the information we have to date whether this will become a criminal charge, but I'm sure, we will all be watching if there are investigations in the future for these really unnecessary deaths, and it will be the police, the prosecutors, and the courts that decide that. Let me look. Can any workplace or sector be charged under the criminal code? Yes, it can. Thank you for the question. I would say that if there's a worker and there's an employer, there's a worker and there's a supervisor, doesn't matter what sector, doesn't matter how big or small the workplace is, that if you fall under the legislation, that there can be negligence and there can be charges and convictions under the criminal code. So I think that will be all for now. And I'd like to thank you again for joining. And it was a pleasure to be with you. Stay well, stay safe. Thank you.